Boom! We've got some absolutely massive Second Amendment news coming straight out of Pennsylvania. And let me tell you right now, this is not your average court ruling. This one is different. This one hits hard. A major state appellate court just struck down a key piece of Philadelphia's gun control scheme. And folks, the ripple effect from this decision could change the game for gun owners all across America. We're talking about a law that's been used to punish everyday people, law-abiding citizens, for simply carrying a firearm in plain sight. No threats, no violence, just the mere act of open carry. So what happens next? The court says that law violates the Constitution. Stay with me, because I'm going to walk you through exactly what happened, why this decision matters way beyond Pennsylvania, and how it's sending a loud message to every anti-gun politician who thinks city limits can cancel out constitutional rights. Here's how it all went down. A man named Mr. Sumter was walking down a public street in the city of Philadelphia, doing what thousands of Pennsylvanians do every day, going about his business, staying alert, and taking responsibility for his own safety. Tucked into his waistband was a legally owned handgun, partially visible, carried openly and peacefully. No threats were made, no crimes were committed, no confrontation occurred. He was simply exercising what he believed was his right under the Second Amendment. But because he happened to be in Philadelphia, just Philadelphia, not anywhere else in the Commonwealth, his open carry was suddenly treated like a crime. Police saw the firearm, stopped him, and arrested him under a city-specific statute known as Section 6108. This law makes it a criminal offense to openly carry a firearm in Philadelphia without a license, even though the exact same behavior would be completely legal in every other part of the state for adults over the age of 18. That's the heart of the problem. The law doesn't criminalize the act of carrying a firearm, it criminalizes where you carry it. Had Mr. Sumter been standing one block outside city limits, his firearm would not have triggered any arrest, citation, or conviction. The law draws an invisible line around Philadelphia and punishes people for stepping over it while exercising a constitutional right. The arrest led to a conviction, and that conviction sparked a legal battle that has now reached a critical turning point. What started as a quiet incident on a city street has exploded into a landmark legal ruling with far-reaching consequences. Because one man didn't back down, because he challenged the charge instead of pleading out, the court was forced to confront the uncomfortable truth. This law doesn't treat Pennsylvanians equally, and when a law draws that kind of arbitrary boundary around constitutional rights, it stands on shaky ground. The appellate court in Pennsylvania didn't dance around the issue. In a decision that hit with the force of a gavel made of granite, the court took a long look at Section 6108 and called it what it is, an unconstitutional restriction that unfairly targets residents of Philadelphia. The opinion pulled no punches and exposed the glaring legal imbalance baked into this city-specific law. At the core of the ruling was one clear principle. The Constitution doesn't apply differently depending on your zip code. The Equal Protection Clause under the 14th Amendment guarantees that similarly situated individuals should be treated the same under the law. What Section 6108 did was carve out a special class of people, those who happen to live or walk within Philadelphia, and deny them rights that every other Pennsylvanian still enjoys. The court pointed out that open carry is legal without a license throughout the rest of the Commonwealth for adults 18 and older. But in Philadelphia, the same exact act suddenly becomes a felony unless you jump through a separate set of bureaucratic hoops. That's not just unfair, it's a textbook example of unequal treatment under the law. And when the court applied strict scrutiny, the most rigorous standard of constitutional review, the state came up empty. The government tried to argue that the law was justified due to higher rates of gun violence in Philadelphia. They claimed the city needed special rules to keep people safe. But the court wasn't buying it. Judges made it clear that concerns about public safety, no matter how serious, cannot override fundamental constitutional rights. The balancing of interests, the weighing of freedom versus security, is not something modern courts are allowed to invent on the fly. That balancing was done already, centuries ago, by the framers when they drafted and ratified the Second Amendment. In quoting prior decisions like District of Columbia versus Heller and NY-SERPA versus Bruin, the court reinforced a powerful message. The existence of crime in a particular city does not give that city the power to rewrite the Constitution. If it did, every densely populated area in the country could declare itself a Second Amendment-free zone, simply by citing crime statistics. That's not how rights work. Rights don't vanish the moment you cross a city line. The ruling declared that Section 6108 placed Philadelphia residents at a special disadvantage when it comes to exercising a core constitutional liberty. That phrase, special disadvantage, is going to stick in legal memory for a long time. It summarizes what so many gun owners have felt for years, that certain cities have tried to sidestep the Constitution under the excuse of safety and order. But this time, the court didn't blink. It stepped in, struck the law down as applied, and reminded everyone watching that the Bill of Rights isn't suspended by urban planning or city councils. This ruling didn't just fix one bad law. It did something far bigger. It fired a legal warning shot across the bow of every city and every politician in America who thinks they can twist constitutional rights to fit local agendas. This wasn't a procedural technicality or some minor opinion buried in legal jargon. It was a clear, thunderous declaration. You can't isolate the Second Amendment within city borders and pretend it means something different than it does in the rest of the country. What makes this decision so powerful is that it didn't rely on a novel argument or some fringe interpretation of the law. It stood firmly on the most basic principles of constitutional law: equal treatment, strict scrutiny, and the recognition that the right to keep and bear arms is fundamental. The court didn't create new doctrine, it simply applied existing law the way it was always meant to be applied. And that is exactly what makes it so dangerous to the anti-gun movement. They can't say this was an activist court inventing new rights or going rogue. The judges simply followed the trail laid down by the Supreme Court in Heller and Bruin. They looked at the history, looked at the text, and applied the standard. And when they did, Section 6108 didn't stand a chance. One of the most damning lines in the ruling was the court's acknowledgement that Section 6108 created a special disadvantage for Philadelphia residents trying to exercise a constitutional right. That language matters. Courts don't toss around phrases like that lightly. It opens the door for other laws to be challenged on the same grounds, laws that discriminate based on geography, class, or arbitrary zoning. If a right is truly fundamental, then it must be protected uniformly, not selectively enforced based on location or population density. And remember this, the court's rejection of Philadelphia's public safety justification wasn't casual. It was deliberate. Judges reminded the state, in no uncertain terms, that the time to weigh safety against freedom happened when the Second Amendment was adopted. That balance has already been struck. The people made their choice, and courts don't get to second-guess it every time someone in City Hall gets nervous. In short, this decision puts teeth back into the Second Amendment. It sends a message that the right to carry doesn't shrink when skyscrapers appear on the skyline or when local governments panic over bad headlines. The ruling doesn't just protect one man, it empowers millions who live in cities where their rights have been quietly pushed aside. Now, they have precedent. Now, they have ammunition. And now, the legal tide is shifting, one courtroom at a time. City governments have been playing a dangerous game for a long time. For years, they've been crafting special carve-outs, building loopholes around the Constitution, pretending that urban areas somehow deserve fewer rights than the rest of the country. Philadelphia, New York, Chicago, San Francisco, they all follow the same pattern. They pass restrictive gun laws, justify them with crime statistics, and count on judges to look the other way. But this ruling out of Pennsylvania just flipped the script. By knocking down Section 6108, the court made it crystal clear you can't quarantine the Second Amendment just because you don't like how it looks in a city setting. Rights don't stop at the edge of a municipal boundary. You don't lose your liberty the moment you step off a farm and onto a sidewalk. For too long, these cities have used phrases like public safety and community protection as shields to deflect scrutiny. They argue that densely populated areas need tighter rules. They claim gun violence gives them a free pass to trample individual rights. But the court didn't blink. It saw right through the strategy and called it what it is: constitutional discrimination. The ruling also undercut one of the most common excuses used by urban anti-gun politicians. They often argue that more people equals more danger, so the rules must change. But the court pointed directly to Bruin and reminded everyone that geography doesn't dilute the Constitution. There's no historical tradition of disarming people in cities, no legal foundation for pretending urban areas are too sensitive for rights to exist. This decision slices through the illusion that cities are special zones where constitutional protections are optional. It tells lawmakers across the country that they can't build policy on fear and expect it to survive the courts. And it warns those who push for local gun restrictions. Your arguments need more than emotion. They need history, logic, and constitutional backing. In the battle between urban control and individual freedom, the tide just turned. City halls should take notice. The courtroom is no longer a safe space for lazy legal excuses. The walls are cracking, and the pressure is building. This ruling didn't just knock down one city's overreach, it lit a signal fire for courts, lawmakers, and gun owners across the country. What happened in Pennsylvania is about to echo in state houses and courtrooms far beyond Philadelphia. Because once one court recognizes that a law like Section 6108 fails the constitutional test, it invites every affected citizen to raise the same challenge. Other cities with similar restrictions should be nervous right now. They've leaned for years on the idea that they could write their own rules, that they could claim special status because they're different. But the truth is simple. The Constitution doesn't carve out exemptions for population density, traffic congestion, or urban design. Rights aren't optional. They don't scale up or down depending on how many people live in your zip code. This decision gives gun rights advocates a new legal weapon. It's no longer just about the Second Amendment on its own. It's now clearly tied to equal protection. That changes the game. Now, a gun owner in any city with an outlier carry law can point to this ruling and say, "I'm being treated differently," and that's unconstitutional, and courts will be forced to answer. It also means state legislatures will face mounting pressure to review and repeal laws that only apply to one city or one class of citizens. The idea of a patchwork legal map, where your rights disappear the moment you cross a county line, can't stand for long, not after this. What matters most is the precedent. When a court draws a line and says, "This far, no further, others follow." It sets the tone, it sets the standard, and it shows that constitutional rights don't shrink when they become inconvenient. What happens next is entirely predictable. More lawsuits, more challenges, more scrutiny of city-specific restrictions. And little by little, those who thought they could govern by exception are going to find themselves boxed in by the very document they tried to sidestep. This case just gave gun owners across America something they've been needing for a long time: a court ruling that pulls no punches, lays down real legal ground, and cracks the door open for a whole new wave of victories. While courts often move slowly, moments like this show that the legal tide doesn't just shift, it gains momentum. This ruling may start in Pennsylvania, but its logic travels well. It sets the stage for others to ask hard questions about enforcement gaps, legal double standards, and the unchecked power of local ordinances. When one community is burdened differently under the same state law, it's not just unfair, it's unstable. And courts don't tolerate instability in constitutional enforcement for long. If you've made it this far, thank you for staying informed and engaged. Your voice in this ongoing debate matters more than ever. I want to hear what you think. Do rulings like this give you hope for broader change, or do they raise more questions in your mind? Drop your thoughts in the comments. As always, I appreciate you tuning in, and I'll see you in the next episode. Stay sharp, stay ready, and stay free.